live. This is Law Call.
Good evening and welcome to Law Call. I'm Ted Howell with the law firm of Perry & Young, and we're here tonight to talk about fighting the insurance companies. We'll have those phone lines open at 850-392-1544, or you can email us at lawcall@wnbb.com. Fortunately, I am here with probably one of the most prestigious guests we could ever summon on such short notice. It is the fantastic Les McFadder. Would not like to do this show with anyone else tonight, and I'm just so happy you could be here and fit us in.
So you're not supposed to make me laugh right off the bat with that. The most prestigious person we could find on short notice. You know. That's a short list, y'all. I mean, it really is. But man, I'm proud.
It is a list.
There is a list. I think it's a list of two.
And you're at the top of that list.
That's right.
But while we hopefully get us a lot of calls going on, let's. I think we got us an email question that we can get us started on this topic. What does it mean to settle a claim, Maddie? A very short, sweet question, but very, very on point for what we're talking about tonight.
It is, and it's right in line with what we do for a living, which is handle personal injury claims, which most often typically do resolve through a settlement, out-of-court settlement. So, Maddie, I appreciate the question. I appreciate the brevity of it. Most of the time, we're still reading the original email question, but it's a great question. What does it mean to settle a case? Essentially, it means that you have met the conditions and the terms. Two parties have come together, two or more parties have come together, and they've agreed to resolve their dispute, and they reduce it to writing, and it basically signifies the end of a legal claim. In the personal injury world, we're talking about injury cases. That typically means we've made a claim against somebody or their insurance company. Insurance for injuries, the insurance company offers money. We go back and forth. We come to terms on how much money our client is willing to accept. We reduce it to writing. They send us a check. The case is over. But once the case is over, people oftentimes come back. A lot of times in our world, we're dealing with people that have injuries that may linger well past the time that a case either settles or goes to trial and you get a jury verdict. So, you settle the case. What about coming back for more?
Right, and there's a lot of issues with timing of the settlement can be very important. I actually had a lengthy discussion with a client this week about the importance at times of trying to settle a claim quickly because, the amount of insurance that an individual has is not the extent of their liability, but in many circumstances, for a practical matter, that's the most you can get because there are a lot of protections in Florida. You cannot go take someone's homestead. Wages can be exempt under many circumstances. So a lot of times you're dealing with what's the available insurance is going to be the limited amount of recovery, or is going to limit the recovery you can get. And there becomes other factors that can play into why you need to try to get that done quickly. For example, if you have health insurance, it will kick in and pay your medical expenses as secondary insurance after your PIP, the no-fault benefits that we have discussed many times, have paid out, which is the health insurance that's built into your auto policy that's $10,000. It pays at an 80-20% copay deductible type of scenario. But if your health insurance has to kick in, they are entitled to get reimbursed when you settle the case out of the proceeds of that settlement. But the timing of that reimbursement gets cut off as soon as you settle the case.
That's right.
So if you're dealing with a situation where there is little insurance, it's imperative to try to get that settlement of that claim done sooner rather than later so that you can have your health insurance continue to pay without having it eat up and take away the entirety of your settlement process.
Right, and that's one of the things, we always, oftentimes on this show, we say, hey, you really want to talk to an attorney to talk about that issue, whatever it may be. And we talk about personal injury cases and how we handle those, and that's one of the main reasons why you want to talk to an attorney is because you want to make sure not only are your rights being protected, but that your exposure for any liens or any obligations that you may have by virtue of the fact that you received a settlement, you want to make sure that that exposure is as limited as possible. So the most classic examples, like what Ted said, you have somebody that has an injury. It could be anywhere from a moderate, minor injury to a catastrophic injury. But if the injury if the injury claim is worth more than the available coverage, oftentimes we can get the available coverage, but then what do we do with the medical expenses? If you have private health insurance that pays those medical expenses and you can settle a case before major expenses are incurred or major expenses are billed to your insurance, The lien cuts off most of the time at the date of settlement, so you can oftentimes have your, essentially have your cake and eat it too. You can get your treatment and not have to pay for it out of your settlement money if you have valid health insurance that has
right. And there's always caveats to that when you deal with certain federal plans.
But it's what we do.
But that's why you need help and you need assistance, because I have seen individuals settle the claim on their own. They get a check, they think it's all good, they go and spend it, and then here comes Florida Blue or Medicare knocking on wanting their reimbursement rate, and it can have serious implications, because if you don't have that money, you can have your benefits cut off.
Especially if you're dealing with Medicare, Medicaid, TRICARE, VA, any government subsidized or government provided benefit. Their interests are protected by either state or federal law, and you can really find yourself in trouble if you do not protect those liens, which again is one of the primary things we do when we resolve a case, is we make sure you're protected from those entities coming back after you by satisfying whatever their obligations are.
Because just when you settle the case and those checks change hand does not mean that your rights that you need to take care of and your responsibilities end. There's many things that still need to be done and need to be taken care of to make sure that your medical expenses are being paid and that you're getting to the finish line and getting as close to back to where you were from before the action as you can.
Yeah, great question, Maddie. Appreciate that. Yeah.
Very good. Well, we're going to be talking about all kinds of insurance claims today. I mean, you name it, they're out there.
That's right. I believe we actually have a call that came in. Go ahead, let's put that call up and hear what they have to say. This is from Fred. Go ahead, Fred. Fred, you there?
I got you.
Fred from Dothan. You got a question, bud? I think we might be having some connectivity issues.
Yes.
Put it back. I had a life insurance policy for 20-some years. Never missed a payment. Never was late with a payment. It was $175 a month, and when it got ready to expire, I got a letter from the company that said it would go from $175 a month to $3,000 something a month. Now, I'm an older fella. Would that be an age discrimination question?
Fred, probably not. It sounds to me like the type of insurance policy that you bought was probably what's referred to as a term life policy. What a term life policy is you buy it for a specific term. 10 years, 20 years, 30, I think 30 years is usually about the max on it, but usually 20 to 30 years is the term of that policy. And during that term, they will agree to pay a death benefit in the event you pass away of X amount, $100,000, $500,000, whatever it may be. The premium is then set based on the amount of money and your age. They know that the older that you get, the higher the likelihood is that you're going to pass away. And so they put a stop date on that. And what they're doing is they're saying, hey, Fred, if you want to renew this policy, we'll give you that same level of coverage, but we're not going to be charging you $175 a month. We're going to start charging you $3,000 a month because you have had this policy in place for however many years. You're older now, the risk is higher. So they're more than happy to write that insurance, but it has nothing to do with age discrimination. It has to do with the risk analysis that is actually set by actuarial scientists employed by life insurance companies.
And life insurance, like auto insurance, I mean, people ask us all the time, if I make a claim on this policy, is it going to make my insurance go up? And the standard answer is your insurance is probably going to go up no matter what. But as a general rule, with respect, when you're dealing with auto insurance, if you're having a lot of accidents, if you're driving more, those kinds of things make you a riskier proposition. As a result, your premiums will go up.
Right.
In this situation, as you get older, unfortunately, death becomes more and more. I mean, we all know death and taxes are one of the few certainties that we have. And as you get older, the chances of you dying in the next year, the next 5 years, keeps going up, statistically speaking. So
that's right.
The premiums go up.
That's right. Fred, there's a couple of things that you might think about doing. Number one, you could call your agent and you can ask them to re-quote for you. Maybe you consider lowering those limits. I know young people out there, people that are just starting families. Maybe you just got out of college, you just got out of trade school, you've got young kids. Usually it's very inexpensive to have life insurance, and it's very valuable in case you were to die, pass away young and leave a young family. So you have life insurance there to help offset those expenses for your loved ones in the event you pass away. But as you get older, the general thought is you start to amass a little bit more money, you have a little bit more stability, maybe you don't owe as much, or maybe you've paid your home off by the time you get into your 50s and your 60s, your debts aren't as high, your kids have graduated and have moved out, so now you don't have to worry about taking care of other people. A lot of people let their life insurance policies just fall off because it's cost prohibitive to pay X number of dollars. If you're a 75-year-old and you had, cancer, your premium is going to be tens of thousands of dollars a month.
And so it's better to save that
It's just
money.
better to save the money. So, but younger people, life insurance is a good idea if you have a family. It's going to benefit them. It's not going to benefit you. But as you get older, you might want to look at different options there. So I'd probably encourage you to reach out to your agent and say, hey, what are my options? I would like to carry some level of life insurance. Maybe it's for something as simple as I don't want my family to have to pay for my funeral.
Right.
You could buy a
low
limits policy or a burial policy that could cover those end of life expenses that probably won't be near as much money as if you're trying to get $500,000 or $1 million in life insurance at an older age.
Right.
So great question, Fred. Thank you.
Absolutely.
So,
but life insurance is one of those things that, like you said, is something you have to assess as you change. There's all kinds of life changes. We talked about this briefly last week, that if you have a divorce or if you have a new kid, there's a lot of kinds of, all these different life changes are times that you need to assess and look at those things. Same things with your auto insurance. As you grow and as you have more family members come along and you have additional vehicles, as you accumulate additional wealth, there's all kinds of things that you need to be constantly assessing and discussing with your agent what your needs are, what your risks are, so that you're making sure that you're properly protected at all angles. I mean, one that I see come up quite frequently is that people think that they have coverage for their animals if there is a dog bite, for example, on their premises. But many policies have exclusions for those, and there's information when you're filling out those applications when you get your initial insurance where you have to disclose whether you have animals or not. Well, if you just keep renewing that policy every year and then you get a new animal and you don't advise your agent of that, they're not going to know that there's been a change in risk, because having an animal, although they're lovely, it is a change in risk. That's something that needs to be updated and analyzed on making sure that you have proper coverage, so that in the unfortunate incident that something happens, I mean, it doesn't even have to be a bite. We have a case in the office right now where someone took their dog, they didn't take it out with a leash, and that dog was a very hyper dog. It ran and it knocked somebody over and it hurt them pretty badly.
Yeah, that's the thing. I mean, the law doesn't say dog bite, it says dog injury.
Right. And it's very close to strict liability with respect to dogs and animals, and there's importance of
Talk about it, strict liability.
Yes.
I mean, we throw these terms around all the time, but you talk about strict liability versus just regular liability and negligence.
As we talk about frequently on this show, just because you fall on business premises does not mean that business premises is liable. They have to have been negligent. They had to have failed to use reasonable care under the circumstances, whether it be not remedying something that they knew of, or letting something sit on the property for too long and not taking care of it. That is just our general negligence. Same thing with our automobile accident cases, that you didn't take care, you didn't use appropriate reaction time, you rear-ended somebody. That was negligence. In other cases, such as in the dog bite arena, we can have what's called strict liability, which means you could have been doing everything right. But something happens and the law decides that they're going to put the burden on you to hold and have culpability if someone's injured. And in the dog bite arena, if someone is in a place where they are legally allowed to be and your dog injures them in some way, shape, or form, Florida statutes provides that that's essentially strict liability on you as the dog owner.
That's right.
So it's important to have that insurance so that you make sure that you're protected in those situations.
Yeah, I've seen that a lot of homeowners policies, because we've seen kind of an uptick in dog bite cases and animal, knocking somebody down, animal attack cases, or even just animals just being, dogs and something unfortunate happens. So, and we find out that this homeowner's policy has an exclusion, or they have a sublimit.
Or they sometimes have sublimits for the low rider, so be careful and look at those. But those phone lines are open. We're going to take our first break of the night. Please give us a call, 850-392-1544. Welcome back to Law Call. Ted Howell and Les McFadder here to answer all your questions. During the break, we got a phone call from Tammy. Tammy, you ready for us?
Yeah.
All right.
Go right ahead, Tammy.
Okay, I was involved in a car accident,
Yes, ma'am.
and it took almost 2 years to settle. And if you want to cut it in fours, the lawyer got 3, and I got 1%. How come the lawyer could make more than you?
Okay, Tammy, there's a lot there in that. You know, the way that the fees work, and it looked like you were in Alabama, so I'm assuming that's an Alabama case that you're calling about, is that the fees are typically, in Florida, they're governed in large extent by the ethics rules, which don't necessarily apply in Alabama. It can be contracted to whatever the parties agree to, but as a general rule, any contingent, not as a general, it has to be. A contingency fee agreement has to be in writing. It has to be set out at the beginning of the case. Typically, it is 1/3 of the recovery is the attorney fee if it's a resolution that is done without a lawsuit, and that typically goes up to 40% of the recovery if it actually has to go to litigation. In Alabama, you have a 2-year statute of limitations, so I'm not sure if you were in suit or not, but that would have been right on the cusp of when you would have to get that. As far as the time, well, hold on, before I go past that, in addition to the fees, you have expenses that have to be reimbursed to the extent the law firm has expended funds, whether that be ordering your medical records, if they had to retain any experts to assist with the matter. Once you get in a suit, you're talking about things like filing fees, deposition costs, things of that nature. Those all should be explained to you, though, and gone over with you so that you understand what you're dealing with. With respect to the timing, a lot of that gets dictated by how long it takes for you to treat, because you can't know the full magnitude of the case until you have an understanding of what your injuries are, and that sometimes can take a little longer than we would like, but that's just the nature of getting into the healthcare providers and making sure you get that treatment so that you can get on that path to recovery. You know, many times, you know, the timing of the settlement, I tell a lot of people, in large part can be dictated by the amount of coverage, because as we mentioned earlier, most folks do not have assets where they could satisfy a judgment in excess of their insurance limits. So in that case, we're going to try to settle that case only if we can get those limits, or if we know that the case is worth less than those limits. So if you have a relatively small policy, you have to really be looking at that case and trying to get it resolved sooner rather than later, because if you don't, the medical expenses, and I'm concerned that that may have been what had happened here, your medical expenses can eat up a large percentage of your ultimate settlement. Conversely, if you have $1 million or more in coverage, we know that that's going to be a case more than likely that is going to be able to handle whatever the value of your claim is. So we're going to want to know everything that's wrong with you before we settle it, because we can only settle the claim once. Unlike health insurance that will pay as you go, that liability policy that you're seeking to recover from will only pay once. And you can't settle it and then come back and get more if you need a surgery or another procedure. So I'm assuming, based off what you've told me, that a large percentage of your settlement, unfortunately, must have had to go towards paying your medical expenses. Or liens, which were resulting from medical expenses. And so you, instead of having to pay them yourselves, those came out of the settlement proceeds. But it's important that that be explained to you and that you understand where you're coming from. I mean,
yeah, you know,
when we're settling cases, we got the client has to understand the figures, because it's not the gross number that matters to them; it's the net number.
That's exactly right. And something that struck me when Tammy was asking her question is it almost sounded to me like she found out when she was getting her money and signing the closing statement that, oh, I'm getting this amount and all this other money goes somewhere else. So that in and of itself is a problem. And so. Look, if you have an injury claim and you feel like you need legal representation, we're always going to tell you go talk to a lawyer. We would love it if you would call us, but we understand there are many fine lawyers out there. But at a minimum, you should be able to meet with your lawyer.
Yes.
Preferably, I mean, at the very beginning, we meet with our clients. We talk with our clients. We explain to them up front how the attorney's fees work. In Florida, the standard contingency fee is 1/3 of the recovery. So if it's a $30,000 settlement, 1/3 is $10,000. $10,000 is the attorney fee, then $20,000 would be the net recovery. We talk about case costs. We try very hard to keep our case costs very low. That is money that we advance to buy medical records, to hire expert witnesses, to pay court reporters, to pay filing fees. We put that money out there with no guarantee that it is going to get paid back, because if we end up not making a recovery, something happens in the case, there's no insurance, we eat those costs. We never assess them against the client. But if we do make a recovery, we ask for those costs to be repaid. We realize that those case costs can get out of hand, and so throughout the process, we're talking to our clients. We're saying, hey, look, we can file a lawsuit, but right now we've got $400 in case costs. If we file this lawsuit and see it through mediation, that $400 in case costs is going to end up being $4,000 in case costs, because we have to pay filing fees, mediator fees, court reporters for depositions, and it adds up. That will necessarily affect the bottom line. So maintaining communication with your client throughout the negotiation process and as the case advances helps the client understand what's going on, and helps temper expectations, not in a bad way, but then you're not surprised.
So and then make an educated decision about
and
what
then
you're
the
doing.
final thing is, if an offer is made, we have to communicate that to our client. We pick up the phone, we have a meeting, hey, they have offered this much. Attorney's fees are going to be a third. Right now our case costs are X. We've looked at your medical bills, your health insurance liens. It looks like we're probably going to have to pay this much back. This is a rough estimate of what you'd probably be looking at, and we usually try to, under promise, over deliver. So, if we can work on some liens, negotiate some bills down, things like that, we try to do that to jack up the client's pocket. But before getting authorization to sell the case, we talk to our clients. We say, hey, look, if we can sell for this amount, you're going to be looking at roughly this in your pocket. Are you okay with that? Because nothing is worse than, flying blind and that sort of thing, and we never want that to happen on our clients. And Tammy, I'm sorry if that's what happened to you. I know not every law firm does it the way we do, but there's a lot of things that lawyers can do in communicating with our clients, so those things don't come as a surprise.
Well, Tammy, sorry you had to deal with that. We'll make sure if you have any other issues, you give us a call and we'll go over it with you. But we're going to take our final break of the evening now, but those phone lines are still open. Welcome back to Law Call. During the break, we had a call from Tim. Tim, go ahead with your question.
Yeah, so I have a person that hit my vehicle not only once but twice, and then what happened is that their insurance company was maxed out at $10,000. So the insurance company encouraged me to go ahead and file a claim with my insurance, which obviously leads to higher rates. So I'm trying to look to see what the best result is for that, because the fact that if I file the insurance claim with my insurance company and have higher insurance rates, that person maxed out because of how they had their policy. They were responsible. They took the initiative and said, yes, it was.
I think,
Yeah, Tim, the issue here is you got to make the best decision under the circumstances. If they only have $10,000 in coverage, which is all the law requires, and if they have that minimum coverage, it's unlikely they have assets that could pay over and above that. Depending on the magnitude of your damages, you are going to need to file on your own insurance if you have that coverage.
Hopefully you have uninsured motorist coverage, which is, I mean, you pay a premium for it. If you need it, you should use it. That's coverage that goes above and beyond a tortfeasor's coverage.
But that's not a fault-based claim on your policy.
Right.
So that's not going to have the same impact on rates as it was if you had caused the accident.
Right.
And that's why you carry that insurance, is for situations like that where you get hit by somebody that doesn't have enough.
That's right.
So quickly, any shout-outs for you, Les?
I do. Miss Pam, I want to give a shout-out. My wife, Jen, Rachel, and Eli are staying up watching. Mr. Gary Starr, tuning in. G-Man. Good to see you, bud. Ed and Jamie, Nick and Lauren, and I want to wish my mom, my sister's in town from Tampa, very special Happy Father's Day to my dad.
Well, I'm just going to wish to my dad, Randy Howell, and to the Godfather, Larry Perry, as well. So y'all have a good evening, great Father's Day, and we'll see you back next weekend.
Happy Father's Day, Ted.
Yeah, happy Father's Day to you, Les.
Thanks, bud.